You guys, I'm about to not be on camera. Look at this look at this crazy shit that keeps happening. Can you even hear me? Can you even see me or hear me? Do I look like super dark? My light is on full blast. It won't go. This is absolutely outrageous. Hold on. I should have just not been on camera. Maybe we could have been here a little sooner. But anyway, it was like turning blue on me. Yeah, super, super dark. That's what I thought. Okay. It is a candlelight chat. While I do love that, like if I'm gonna actually be on camera, I want you to actually be able to see me. But at least you can hear me. You can see me and my beautiful bubby. I do think I have another light I can look for. But anyway, how is everybody? Oh, of course, Beats. You liked me on camera. I bet you I do have one. I have another light, I think. That's probably not going to work either. You know, I think it's because I'm at my mom's and she's got like yellow walls with a lamp, a single. First of all, I'll tell you this. I'm far too blind to come to my mother's house because I can't ever see. She's used to walking around with no lights on because like we don't have stock in Pico. And so when you're going from one room to the next, you have to like shut the light off from that room. Well, I'm too blind to see from one room to the other. And then your eyes get adjusted and then you go to another room, you got to shut it back off. And so in here, she's got like this super dim light that's like also orange and yellow. And when I was trying to set up my camera, I kept turning blue. And then my light died. Let me look and see before we get all into this. So, yeah, my mom literally, like, she'll shut the light off and she'll go looking for something. And I'm like, how the fuck can you see? You're like way too old to be walking around in the dark like that. But she does. We don't have stock in Pico. If we did, we'd get to keep the lights on all the time. I hope everybody had a good Thanksgiving. Sleuthy Smurf. Yeah, that's literally what I looked like. Just randomly, it would go blue. Holy crap. Now this is bright. Oh my gosh. Hold on. Hey, Willie. Well, I guess if I'm blind, but you can see me, you'll be pleased with that. Let's see. When your eyes are dim, it doesn't much matter. Yeah, right. Well, like, I don't know. I like to see what I'm gonna trip over before I trip on it. And I got this weird octopus looking thing. It's supposed to stick on your computer. Let's see how many seconds it lasts for me. I need a light person. I need someone to just hold it for me. Oh, Lord. I really had some stuff I wanted to accomplish today. Maybe if I don't move. I'm waiting for the comments like, are we ever going to get into whatever it is we're doing here? I think my hair's just black. That's the problem. I'll tell you what, I'm not tired of fucking with this. I'm just tickled you can hear me. That's really what matters anyway, because I'm going to be off the screen. I just heard something slam, and now I'm afraid it's my poor mother walking around in the dark. I'm stalling. Okay. 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 So, what I wanted to do was talk about the accusations made by Judge Gull in the transcript that we all have now. Because I was looking into them, I wanted to see like how many were legit and how many could maybe be argued, how many are just hot garbage. And I gotta say, I am not seeing what she's seeing. So I want to know if you guys are seeing what she's seeing. What do you mean you can't wait to figure it out how to stream? All you got to do is go into StreamYard and click show me them. Show them to me. Show me to them. Okay. What about now? Oh my gosh, I'm so dark. Like, unless I get like all the way, you want to be this close to me? Look, and then I disappear. What the fuck is going on? I'm over it. Forget it. Forget it. Okay, so I want to share my screen with you. Let's figure out which one. I did try Deets. I tried so hard. We've been here how long? I tried all that time. 12 minutes. I've been trying for 12 minutes. And I'm not comfortable with myself enough to be all up in the camera like that. Okay. So let's pull up the hearing transcript. Oh, I haven't done this in a minute. Blair Witch vibes. All right, let's zoom in here. All right. So I want to go down to the part where she starts talking about, in no particular order, who abandoned you? Hold a flashlight under your chin. That's almost what it looked like. Okay, here's her thoughts in no particular order. Then she goes on about sheriffs and yada yada. We want to get to the part where she's talking about what they did. Okay, right here. I can make that bigger for you guys. Can you see that? We're only going to read just a little bit. Let me know if you can see it. Yep. Okay. So the first accusation that she makes, she says, defendant filed a verified motion for immediate transfer of custody. The state filed its response. The motion, again, has a lot of inaccuracies and some speculation, as it has been refuted ably, I think, by the affidavits that have been submitted by the state, and I'm going to deny the motion. So now, this particular affidavit that she's talking about, or motion, the motion for immediate transfer of custody, there's been several of them, we know this, and they've been denied. But the thing is that this one was the first one after all the extra stuff they found out was found out. So everything that had to do with Odinism and the guards that were watching him, etc., etc. This one, in my opinion, is really important because it really, really lays heavily on reading the Franks memo, okay? So let's pull up the verified motion. And we'll zoom all the way in. Surely to God we can see this. Okay. So 1, 2, and 3, I'm not gagged on Idaho. There's just what I'm waiting for has not come out yet. I don't really feel like talking about the same thing over and over and over again. I'm waiting for documents. Ever since he waived his fast and speedy, it's like it's going hella slow. All right, so 1, 2, and 3 is like really simple stuff. basically when he was arrested, when Diener put in the safekeeping order. Surely she doesn't think that that stuff is inaccurate, because it's not. So number 4 is that counsel for defendant Allen have previously requested that defendant Allen be removed from the Westfield Correctional Facility on the basis that defendant Allen has been exposed to conditions far more harsh than those of other pretrial detainees across the state of Indiana. Pretrial detainees. In its order on July 19th, 2023, the court denied counsel's request for transfer and in fact found that defendant Allen was being, quote, treated more favorably than other inmates housed at the Westfield Correctional Facility. Inmates. That is Willy Willy. It's Willy Willy. Counsel for defendant Allen believe that it is improper to compare defendant Allen's circumstances with those of other offenders who have been convicted of crimes such as murder, rape, child molesting, and robbery, to mention a few. Do you guys agree with that? Like, it very much felt like she missed the point. She was comparing apples to oranges as opposed to apples. So they're like, listen, he should be moved. He's being treated worse than any other pretrial detainee in the state of Indiana. And she's like, well, but he's not being treated than any other convicted murderer. So do you guys see anything inaccurate yet? Yeah, Deets. Deets said, did she forget he's still innocent? It's funny, when I was reading the affidavit, it almost seemed, or not the affidavit, the transcript, it almost seems like the answer would be yes. Yeah, I think, yeah, so she said, okay, defendant Allen's incarceration in the maximum security unit has exposed him to the most isolated conditions an offender can be subjected to while imprisoned. Moreover, the unit wherein he is currently being isolated is designed for the sole purpose of segregating and punishing the worst and most heinous offenders in our prison system. As an innocent man, defendant Allen cannot be classified as such. Attorneys for defendant Allen have discovered additional circumstances which lend support to the unjust and inhumane conditions under which defendant Allen has been detained for the past 9 months. So they're saying, we've found new circumstances that we want to present to you because we feel like surely now with these additional circumstances, you'll feel obliged to let him move somewhere safer as a pretrial detainee who is still innocent. So number 5. Simultaneously herewith, defendant Allen's attorneys have filed various pleadings, including but not limited to a motion for Frank's hearing, hereinafter Frank's notice. Within the Frank's notice and supporting memorandum, defendant Allen's defense offers up numerous facts and circumstances which connects members of the Sons of Odin, aka Odinites / Odinism / Vinlanders, and various other splinter groups, a white supremacist group, to the murders of Abigail Williams and Libby German. A large majority of the facts and circumstances referenced in the Frank's notice and supporting memorandum were obtained through the normal course of discovery from law enforcement files. It is, however, notable that there have been very few, if any, references by law enforcement authorities to these Odinistic ties throughout the 6-year investigation in this case. Said information was noticeably absent from the probable cause affidavit filed with this court on October 28, 2022, which supported the search of defendant Allen's home. Council incorporates herein all references to the sons of Odin, Odinites, Odinism, Vinlanders, etc., referenced in the Franks notice and supporting memorandum. So, we'll stop right there, because one could argue that perhaps those things are not accurate, all of the Odinism stuff. The problem is, though, is that this bitch never read it. You haven't even read it. You haven't even got to the bottom of the 136 pages where he talks about the Odin patches on the guards. So you can't say that this is inaccurate because all of the evidence to back up this tiny paragraph's worth of statements is in the Franks memorandum, which you have admitted to in the October 31st transcript, which I could pull up if you guys would like, where she says she hasn't even gotten through all of it yet. She hasn't finished reading. So, in my opinion, a large portion of the evidence to back up this request for transfer comes from a document that she hasn't yet read. And so my problem with that is then making a decision based on not getting the full picture. You essentially only made your decision based on the state's response and the affidavits that were filed that said that what they're saying is true. So I don't understand where she... As soon as you all start seeing inaccuracies, please just let me know. But that bothers me because they're clearly saying in the 5th paragraph that a lot of the evidence that supports what they are trying to say and their reasonings for wanting him moved is in that memorandum, and you have not read it. Yeah, Kate said the fact that she hasn't read the 136 pages says everything. Dude, that thing came out, like, by the time they went to court on October 19th, I think most people had read it multiple times. Now, I get that she has to read through and listen to all of the interviews and the various exhibits and photos and everything else that was filed with it. However, you didn't get past the first 136 pages though? Like, why? Like, why? Did you start reading and then something was bothering you and so you're like, oh, I'm not going to read this anymore? Because it certainly wasn't boring by any stretch of the imagination. All right, so number 6. Allen's defense team, including Andrew Baldwin, Matt Hoffman, Max Baker, and undersigned counsel, which would be Rosie, that's who filed this, have visited Westville Correctional Facility on a number of occasions dating back to the winter of 2022. During one of the initial visits to the maximum security unit, members of the defense team noticed the presence of unusual patches on the uniforms of 2 prison guards, Sergeant Joshua Robinson and Sergeant Randy Jones. One patch consistently worn by Sergeant Jones reads as follows, "In Odin we trust." Counsel has also observed patches containing 3 interconnected triangles on the chest of Sergeant Jones. Sergeant Robinson has worn similar patches with Odinistic references. As mentioned in the Franks notice and supporting memorandum, these patches with their references and symbols have direct ties to the practice of Odinism. So once again, you're relying on the reader having read the memorandum and the notice that you're talking about. Any inconsistencies yet? So the accusation is that Gull's accusation is that there are inconsistencies in this document. Number 6 says that there are 2 guards at the prison who are wearing patches that say, "In Odin we trust," and have the 3 interconnected triangles we know that this can't be an inaccuracy because we do have affidavits by those two guards themselves, Sergeant Jones and Sergeant Robinson, as well as the warden, saying that they do and have and were allowed to wear these patches. So we still have, I think there's like 14 or 15, so surely we're going to hit the inaccuracies at some point. I can actually zoom this in a little more. All right, number 7. Members of the defense team have also observed patches on other guards during visits to the facility because of the very limited contact and brief interactions. It has been difficult to document and even corroborate the actual words and symbols on these patches. Number 8. Through the discovery process, defense counsel has sought out from the DOC video footage from Defendant Allen's cell and video of many of the movements of Defendant Allen within the facility. To date, the defense has received video from November of 2022, as well as additional footage from April, May, and June of 2023. A great number of the videos reflect that Sergeant Jones is commonly assigned to the movements of Defendant Allen in and around the facility. I think we're all still on the same page. On Tuesday, May 30th, 2023, Attorney Rosie, Assistant Max Baker, and Kathy Allen visited with Defendant Allen at the Westville Correctional Facility. The visit occurred in the traditional visitation room used by other inmates. The DOC officials cleared the room so that only Defendant Allen, his defense team, his wife, and DOC employees were present during the visit. During the visit, Sergeant Jones stationed himself within 15 feet from Defendant Allen as he, Allen, and his wife were allowed to communicate with each other from opposite sides of the table. Sergeant Robinson was also present for the transport of Defendant Allen from the visitation room. There was no privacy afforded to Defendant Allen and his wife during this visit. The room was nearly empty, and therefore there was no background noise of any kind to offer up any sense of privacy to Defendant Allen and his wife. Sergeant Jones remained at his post during the entire visit within earshot of Defendant Allen and his wife. So, actually, the corroborating statement that applies to that came from the state's response to this, where McClellan says that, yes, Sergeant Jones was at his post. That's the post that he was told to post at. And the defense is suggesting that he leave his post so that Richard Allen could have privacy for a discussion with his wife. And it's like, okay, but that's not really the argument. The argument, like, are you routinely clearing out the visitation room for all the other inmates to have visitation so that they're private with their family member? Something tells me the answer would probably be no. But he missed the point. Like, regardless, that's not an inaccuracy. Okay, so surely we're getting there. All right. As stated, Allen's defense team received videos from the Indiana Department of Corrections illustrating interactions between prison guards and Mr. Allen during his incarceration. One such video represents an incident which appears to have occurred between May 18th, 2023 and May 25th, 2023. In the video, Sergeant Jones can be seen warning Defendant Allen that he will be tased if he, Allen, does not remove his hands from the cuff port in the door of Defendant Allen's cell. Defendant Allen did not remove his hands from the cuff port, which resulted in Sergeant Jones deploying his taser to Defendant Allen's hands. No use of force checkoff sheet was completed, as it appeared from the communications between the officers that Sergeant Jones did not believe that Defendant Allen was actually struck with the taser. The issue of whether or not he was struck by the taser is of no consequence. At no time during this altercation was Defendant Allen posing any safety risk to any of the officers involved or any of the other inmates housed in the facility. Defendant Allen was securely locked in his cell within the most secure unit in Westville Correctional Facility. and the only aspect of noncompliance involved defendant Allen's hands sticking out of the small rectangular sleeve in the cell door that is used to exchange food, medications, and other items with the inmate. Now, this particular fact was also, I could pull them up. Just let me know at any point in time if you want me to pull up the various affidavits, because I will. But the affidavit by Sergeant Jones admits to having tased him, of him being tased twice between those dates. Once we get into number 11, it'll give you the other one. But their whole thing is he wasn't complying with their orders, and that's why he was tased. But that doesn't make the statement of he was tased through the little rectangle hole that they slide trays through inaccurate. So still yet we're not at the inaccuracies. We're running out of space. What the heck just happened? All right, let's go to 11. There exists a second video, which appears to have been taken between the dates of May 19th, 2023 and May 15th, 2023, wherein defendant Allen is locked securely in his cell. Prison guards appear to be removing handcuffs from defendant Allen, presumably after transporting defendant Allen back to his cell from some other location within the facility. While it is difficult to tell, it appears that Sergeant Jones may have been present during the incident. Either way, an unknown officer deploys his taser, striking defendant Allen's hands. Again, there was no safety threat being posed by defendant Allen at the time of the tasing incident. Okay. Blah says they haven't heard any inaccuracies yet. Has anybody heard any inaccuracies yet? As I said in the affidavit, both of these tasing incidents were confirmed by the sergeants that work there, that were present for the tasing incidents, and Nicholas McClelland. Okay. Leonard Amber said, no, because the defense doesn't just make things up. That's not how any of this works. I understand that. You understand that. However, the judge is saying that one of the reasons why she removed these men from this case is because this motion had inaccuracies in it. So we're going to go find the inaccuracies. I've yet to hear one, but I'm hopeful, because surely a judge can't and won't just lie, right? Okay, number 12. On April 28th, 2023, DOC inmate Robert P. Baston, while housed in the maximum security unit at Westville Correctional Facility, filed a letter with the court. Within this correspondence, inmate Baston claimed in pertinent part the following: there are corrupt officers and ranking officers calling Richard Allen a kid killer, teasing him that he has a visit from his family. On Friday, August 4th, 2023, Attorney Rosie and Assistant Baker visited with inmate Baston at the Westville Correctional Facility. During said visit, inmate Baston told both Rosie and Baker that Sergeant Joshua Robinson was one of the guards that was playing a prank on defendant Allen. At the time of this meeting, inmate Baston was unaware of any concerns that the defense team had regarding Sons of Odin and their involvement in this case. And we've seen the letter, so we do know that Robert Baston wrote a letter. Now, with regard to the stuff that he said, we don't know if that stuff shook out true. But they're explaining what they were told. So is it an inaccuracy if that's what someone was telling you? Hmm. Nope. Okay. And if you look at the state's reply for this, their response was essentially that inmate Baston has claimed corruption like a bunch of times and he's tried to do things to get his sentence to go down and this and that. But like testifying on behalf of Richard Allen doesn't do that. That doesn't help him. It wouldn't help him get out sooner. Like, we get it. Like, he's not a great fella, but like, that doesn't mean that he's not telling the truth about what he's witnessing. All right. We're running out of space here. Maybe it'll be the last paragraph. Number 13. Oh, and again, see affidavit of Max Baker attached to the Franks notice. So again, we're kind of like leaning on the impression that the person reading this motion to transfer this man has also read the Franks memo, which we know she hasn't. So, number 13, the defense team has sought out and offers up herein a DOC video that appears to have been recorded between April 17th, 2023 and April 21st, 2023. During the video, defendant Allen is being transported to a location within the maximum security unit to get a haircut. During the transport, an unidentified prison guard is walking defendant Allen on a leash. Sergeant Jones can be seen in the same video. At approximately 2 minutes and 17 seconds into the video, the unknown officer with the leash reaches up to his right chest area and removes a patch from his uniform, placing the patch in his pocket. It appears from the video that someone, most likely the individual holding the video camera, prompted the unknown officer's actions. Counsel has been unable to identify the specific officer involved or the contents on the patch, and therefore cannot confirm that said behavior is directly linked with the Odinistic practices referenced herein. However, one need not have a degree in rocket science to conclude that staff members are attempting to conceal obviously unacceptable practices within the secured walls of the maximum security unit. Yeah. We still didn't. Okay, we're still not there. I think this is like the last paragraph. If we're not there. Oh, wait, nope, there's more. Okay. Defense counsel began taking depositions in this case during the week beginning August 7th, 2023. During that week, counsel deposed both Sheriff Liggett and Detective Jerry Holman. It was during these depositions that defense counsel first raised issues and offered up exhibits pertaining to the Sons of Odin / Odinism and its obvious ties to these crimes. Thereafter, counsel visited defendant Allen on 2 different occasions since Allen's defense team put the state of Indiana and its investigating officers on notice of the Odinistic ties to this case. The visits occurred on August 17th, 2023, and again on August 25th, 2023. During the August 25th visit, Attorney Rosie observed that Sergeant Robinson no longer had a patch on his chest. This change of circumstance is likely more than coincidental. It could easily be inferred from these circumstances that prison officials are now aware of the Odinistic ties to this case and have instructed their guards and other staff members to remove/conceal their patches during videotapings of defendant Allen's movements within the facility as well as during visits by members of the defense team. Now, could this be maybe what she's talking about? Because I'm thinking, they were allowed to wear the patches, right? So, but then the defense team brought this up. And the warden says in his affidavit that the reason he told them to stop wearing the patches was because the defense team brought this up. However, if you wanted to be really picky, you could say, well, you're accusing them here of only not wearing the patches when you're present versus you mentioning this and putting it out there for everybody to know about prompted them to have to remove them. Is it bad? The mic sound, I guess. I can't win today, I don't think. All right, let's finish. Oh my gosh, there's more. Okay. On June 13th, 2023, this court conducted a hearing on various issues, including but not limited to the safekeeping order. At that hearing, Sheriff Liggett testified that he had made a visit to the Westville Correctional Facility and insinuated that it had been several months prior to the June hearing, but could not remember the exact date. In his deposition on August 8th, 2023, Sheriff Liggett then acknowledged that he had visited the Westville Correctional Facility in the company of Trooper Holman and investigator Steve Mullen sometime in late 2022 or early 2023, but he couldn't recall the exact month of the visit. So then they included deposition transcripts. It appears there were ties between the Carroll County Sheriff's Department and the Westville Correctional Facility, despite the issuance of the safekeeping order, which otherwise divested the Carroll County Sheriff's Department of its jurisdiction over the custody of Richard Allen. That is to say that the Carroll County Sheriff's Department has a vested interest in defendant Allen's continued incarceration in and amongst a culture which appears to be ripe with Odinistic connections. I wonder why they did go there. Like, didn't they get rid of him because he was like, then he would no longer be their problem, I thought. I agree with this. Lee said, no religious symbolism should be worn on the state's dress code attire. Personal necklaces, etc. may be up to debate, but allowing the state attire to be religiously altered is not permitted. And so you could get me on the necklaces, right? Because it can be tucked into. So when one of the guards wrote their affidavit, they said, I wear my patch the same way a Christian wears a cross. No, sir. No, sir. Because I wear a cross. My cross is tucked into my shirt. You can't see it unless I want you to see it. So if I was going to wear a cross, like the only reason to make it in a patch is because you want others to observe that that is your religion. By all accounts, there are Odinists in prison, including by, and we'll get to that, a undercover trooper that's in prison who's well aware of these Odinists inside there. So if you are of the Odinism that is nonviolent and not white supremacist and stuff like that, but you know that they exist inside the prison system, why would you then advertise yourself to them unless you wanted them to think you were like them? I mean, am I crazy? It seems like something really simple to wrap your head around. I just don't, and the warden was allowing it. And they had no shame. Like, they were like, yeah, we were wearing patches. Yeah. I still don't see anything that's inaccurate. Of further concern is the fact that there exists literature. Okay, so now we're gonna list and provide different articles written by various places. We're back into the situation where if those articles are incorrect, that's not necessarily these attorneys that are providing inaccurate information. All right, it says, a further concern is the fact that there exists literature such as a 1998 article from the Southern Poverty Law Center titled New Brand of Racist Odinist Religion on the March, which focuses on the growth of a neo-pagan white supremacist group within prison systems across the country. A local news article published by WRTV Indianapolis titled These Are the Hate Groups Operating in Indiana, published on November 18, 2016, identified many of the hate groups and other extremists who were operating within the state of Indiana. Many of these are associated with the Odinism and or splinter groups such as the Soldiers of Odin, Vinlanders, etc. The United States Supreme Court in 2005 issued a ruling in Cutter v. Wilkinson, wherein the justices found that prisons must accommodate unusual faiths such as Odinism. There can be no doubt that prisoners with Odinistic beliefs and practices continue to grace the halls of our prison system today. Yeah. Okay. So now we get into this undercover trooper. On Wednesday, August 23rd, 2023, Attorney Rosie deposed an Indiana State Trooper, herein referred to as Trooper X, who has served for many years on task forces and as an undercover agent infiltrating hate groups in our state. Trooper X was sought out and consulted by law enforcement investigators in this case for his/her expertise with Odinistic practices and activities within Indiana. During the deposition, Trooper X acknowledged that Odinism consisted of two types, the good and the evil. Said trooper further confirmed that he/she was aware of the existence of the evil side of Odinism operating within the prison system in Indiana. See deposition transcript, and I have that. I can pull it up. It is possible that Westville Correctional Facility has cleansed itself of any such prisoners, and any activity of this sort, not likely. Moreover, to the extent there is an innocent explanation for the odonistic content on the patches, it is not unfair to ask why guards would be permitted to advertise and promote the views of such a radical hate group in an environment where inmates routinely associate with the very same evil belief system. And by extension, one might opine as to why guards assigned to Defendant Allen happen to be the very same guards advertising the odonistic patches on their chest. So, make you a little uncomfortable? Yeah. But is it inaccurate, though? I don't think so. I do not think so. Sounds pretty accurate. And if she didn't like it and this made her uncomfortable, it doesn't matter. It doesn't matter. She doesn't get to, like, feel uncomfortable and then make decisions because the stuff that somebody's saying offends her. She can't. She's supposed to be neutral. I'm going to wait here a second. Well, you know what? Oh, this is the last one. Let's just finish it, and then I'll ask, because I know somebody's sitting here going, psh, there's inaccurate shit in that thing, and I want to know what it is. So you could tell me here in a second once I'm done reading. Number 18. Attorneys for Richard Allen request that his safety be prioritized and that he be removed from an environment that approves of and promotes the odonistic brand. Again, we have the warden saying that he did and does allow them to wear patches. The only reason he ordered them to remove them was because the defense brought this up. Counsel further requests that he be transferred to a correctional facility such as the White County Jail, where he was previously held without incident. In the alternative, counsel requests that Defendant Allen be transferred to the Cass County Jail, where he could be housed in a more modern and suitable jail, one designed and intended to house pretrial detainees, those presumed by our Constitution to be innocent, until the charges in this case are fully adjudicated. And then see here? Can you see right here? See this right here? I swear and affirm under the penalties of perjury that the foregoing representations are true. So this is a sworn motion. They're saying we are not lying, and this woman is saying that there's inaccuracies in this document. I want to know where they are. So like I said, I know someone's sitting in here thinking about how many inaccuracies there are here, and I'd like for you to point them out. I'd appreciate it. We all would. And again, I would also like to know how she would be capable of determining that this stuff is inaccurate when almost every paragraph has you refer back to the Frank's memorandum that she hasn't read. And we'll wait. Everything's moving super slow. Come on, guys. Judge Gull is a lying liar from Liarsville, allegedly, in my honest opinion. Yeah, see, but this is a problem for me. So, brutally honest said her feelings of her being annoyed with defense amount in her head to things being inaccurate. I mean, if that's what it is, well, A, that's not okay, but B, She literally essentially made a record in this transcript, and like this is what she's saying, this is one of the things she's saying she removed them for. Is this having inaccuracies? There are none. Unless I'm still waiting for someone to explain to me what they are. Exactly. So there's a big difference. So Dietz said, I didn't hear any inaccuracies, things she's not happy with, sure. No inaccuracies though. So, but she wouldn't say in the transcript or in their hearing that there's things in there that she doesn't agree with or things that, make her uncomfortable, because nobody gives a fuck. Her job is not to even sit there and be uncomfortable with this stuff. So she worded it exactly how you said, in a way that would be appropriate, which is saying that there's inaccuracies in here, because there shouldn't be. There should obviously be, so we're talking about a double murder. There should obviously be things that make you uncomfortable. And there'll be stuff you don't agree with. And there's allowed to be. But to outright accuse them of lying, literally, that's not okay. Because we just read through the whole document, and most people won't get past the judge saying that there were inaccuracies. So that's a problem for me. They won't actually go look at the document to see if there actually are. Exactly. She would have had to read it first. It's just so crazy to me. So the next thing, so that's the first accusation she makes. We can get out of that. Let's go back to, then this isn't really like one of the accusations, but she says, the defendant then filed a motion for broadcasting order. The state filed its response. Your motion's overbroad. It's got a lot of irrelevant verbiage in it. Says fucking who? Irrelevant to who? Irrelevant verbiage to who? You? What? And since when is, you know what? I'm incredibly bothered by denying a motion to have a man transferred when you haven't read the entirety of the information available to you to be able to determine whether he is in danger or not. Right, so she gets through that. She complains about the media knows what to do if they want cameras. All right, Francie, where's the rest of your accusations? I mean, this thing should be rife with every single thing they've ever done wrong. It's difficult finding them. Oh, not really an accusation, but she says, I had my staff mark the memorandum confidential after it had been filed and disseminated to the public because the actual warrant was in there, and that's covered under a miscellaneous cause number. I'm happy to have a hearing. But didn't she tell the Supreme Court that the reason that she made that Frank's memorandum confidential was because the defense didn't redact the minor victims' full names? So is she lying here in the hearing, or was she lying to the Supreme Court? There's an inaccuracy. It's funny too, if you look at the two sergeants' affidavits, and you look at the state's response and what Nick McClellan said, he actually at one point even says that one of those sergeants doesn't even work in the pod that Richard Allen lives in. And then in his affidavit, in that sergeant's affidavit, he's like, I've been the acting supervisor of of that pod since like late February, early March. So like, did you even ask Nick? Like, Nick, did you even ask them? Um, Also, I said it before on my Twitter, I find the timing of that super interesting because months and months after, same, all same. I just assume they're all lying at this point. Um, what was I going to say? What was I saying? What was I talking about? The pod. Oh, that all of a sudden, so he's there for months, right? So he's in prison. He's in solitary confinement. Like, as far as we know, um, nothing was different. And so it's not like he moved and then all of a sudden decided to confess or whatever. The only thing that changed was that one of these sergeants with the "in Odin we trust" thing, uh, truth and translucent. I don't, and I was when I was reading, I wasn't really looking at the chat. No, nobody's banned. I don't even have mods to even do. I mean, I do, but I don't like tell them when I'm going live, and they don't do anything. They don't have to. Um, there's so much to uncover with Idaho excuses. It's not even. Listen. I don't talk about everything that's said on Facebook and in Reddit and every article that the mainstream media puts out about their anonymous source that they spoke with and stuff like that. Like, I don't do that. And so once the court documents pick up, then I'll start talking about it more. But I'm not going to start. First of all, I got kicked out of the Facebook group. So any rumors going around from the Facebook group, like, I don't even know what they are because I can't see them because they booted me. So I talk about the documents. The documents that have been coming out is just simply FBI needs to turn it over at a certain point. All the pretrial motions that I was waiting for, it got pushed off. Yeah. I mean, Judge Gull should just be like some other people. Like, there's a lot of people here that are like, it just sounds like she just don't like them. Yeah, it does. So instead of lying, why don't you just say, I don't fucking like you. Like, I just don't like you. That's okay. She can not like them. She can't lie to remove them. She tried, though. It made her sick. That's what my mom would say. God got you back. Like, in real time. All right, let's find the next The next inaccuracy. Well, those were the inaccuracies. So are we all in agreement? Like, has anybody, did I miss the people that were pointing out the parts that were inaccurate? I didn't see any. So the next one, oh, this is a good one. This is a real good one. Okay. So she says, I have concerns regarding the defense team and the totality of the circumstances surrounding your representation of Mr. Allen. Candidly, my concerns began at our hearing on November 22nd of last year. You mean like right when they got hired? You immediately were concerned? Already? Okay. Goodness, I'll say. I totally read this wrong. She said Facebook groups are a whole cult of their own, and I thought it said Facebook groups are a whole trash can of their own. Both are true. All right. So, McClellan filed a motion for gag order, and we were in chambers, and you assured me, gentlemen, we don't want the media in our lives. We will not try this case in the media. And less than 2 weeks later, you issued an undated press release that contained an awful lot of information that would not normally be revealed. I don't know. I think you knew, or should have known, that those potentially violated Rule 3.6 of the Rules of Professional Responsibility. So, number one, you don't know if they violated them, ma'am? So they just potentially could have, but they didn't. Or what? They potentially could have violated the rules. Let's look at those. Now again, T, you don't have to apologize ever. Plus, like the first 30 minutes, we were trying to figure out just what the fuck was going on, to be honest. I was blue at one point, and it was really dark. Present. Okay. So she doesn't know if they actually violated them or not. You get a tardy patch. Tardy patch for T. The T stands for tardy. I think I was late. No, so, okay. The reason that she put out a gag order was because the defense put out a press release. Like they put it out on like December the 1st. This woman issued the gag order on December the 2nd. So there's no doubt that their press release resulted in a gag order. And she admits it here. Like, I had to make this gag order because you put out this press release I didn't like. So I want to show you. I looked up the rules. I already know I'll have to zoom this in. Let's see. It's still, oh my gosh, that's still so small. Okay, hold on. I got you. Is that better? A little more? Let's do a little more. So these are the rules she claims. Why? Why are they, what is this? Like, why is this so, this takes up all the space. All right, but you can see though, right? Okay. So this is the rule that she says potentially violated or they should have violated. I don't know. The wording's really wishy-washy. Not real clear. So yeah, Bobby. So she wasn't saying that they violated the gag order. She was saying that, let me read it exactly what it says. Less than 2 weeks later, so they had an in-chambers meeting, I guess, where the prosecution filed a motion for the gag order. And the defense attorney said, we don't want the media in our lives. We'll not try this case in the media. She says, and less than 2 weeks later, you issued an undated press release that contained an awful lot of information that would not normally be revealed. I don't know. I think you knew or should have known that those were potentially violative of Rule 3.6. So we looked up Rule 3.6. This is it right here. And it says, a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Notwithstanding paragraph A lawyer may state. Okay, so now we're at what they may state. Okay. Number 1, the claim, offense, or defense involved, and, except when prohibited by law, the identity of the persons involved. Number 2, information contained in a public record. Number 3, that an investigation of a matter is in progress. Number 4, the scheduling or result of any step in litigation. Number 5, a request for assistance in obtaining evidence and information necessary thereto. And number 6, a warning of danger concerning the behavior of a person involved when there is reason to believe that there exists the likelihood of substantial harm to an individual or to the public interest. And 7, in a criminal case, in addition to subparagraphs 1 through 6, these are all things that they may state. Okay? The identity, residence, occupation, and family status of the accused. If the accused has not been apprehended, information necessary to aid in apprehension of that person. The fact, time, and place of arrest, and the identity of investigating and arresting officers or agencies and the length of the investigation. Notwithstanding paragraph A lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. You got that part? Because they explain it here. I'm going to show you what they said. Because they're basically saying, the defense basically said, they've put a lot of prejudicial shit out there throughout the last 6 years. We want to put our side out to kind of balance the scales again. Okay. Let's do this a little more. Whoa. Does everyone remember this press release? Seems a lot of people don't remember it even. All right, people. I think the chat keeps, I don't know, slowing down, and then I don't see anything a while, then I see multiple things come up. All right, here's the press release. As Rick, Allen's attorneys, we have received multiple requests from local and national media for interviews and comments since the unsealing of the probable cause affidavit. It would be virtually impossible to comply with these requests and continue to focus on the merits of Rick's defense. Therefore, we offer up these thoughts. So, yeah, I am in StreamYard. However, I never go live anymore, Deets. And so I stopped paying. And I think they mess up when you don't pay. If I was consistent, I would just pay. We do not want to try this case in the media. It's literally the first sentence. And we intend to adhere to the Indiana rules of professional conduct. Oh, the ones that Judge Gull literally just said. On pretrial publicity. However, the police and prosecutor's office have conducted many press conferences over the 5+ years of this investigation and following our client's arrest. On the other hand, Rick's ability to assert his innocence has been reduced to only one short post-hearing press conference. Accordingly, we feel it appropriate, necessary, and within the bounds of our rules of professional conduct to make a few comments regarding the probable cause affidavit and Rick's innocence. So, this thing that we're fixing to read right now is one of the reasons. So we already got through the other document that she said one of the reasons she booted them was because there was inaccuracies in it. None of us could find any. Another reason she booted them for it is because of this press release. So we're going to see what's so bad about it. Rick is a 50-year-old man who has never been arrested nor accused of any crime in his entire life. He is innocent and completely confused as to why he has been charged with these crimes. Where's all the people in the back that says, if they were innocent, wouldn't people be saying, wouldn't the lawyers and the family be saying he's innocent? Well, the family's under a gag order, right? But the lawyer said it right here. He's innocent, completely confused. This was right after the probable cause affidavit came out. The police did not contact Rick after Libby German and Abby Williams went missing. Rather, Rick contacted the police and voluntarily discussed being on the trail that day. Like many people in Delphi, Rick wanted to help any way he could. Rick contacted the police to let them know that he had walked on the trail that day, as he often did. Without Rick coming forward, the police probably would not have had any way of knowing that he was on the trail that day. What do you think about that? It's so funny because it's again one of those statements that makes you uncomfortable. You probably don't want to hear it, but that doesn't mean that it's not true. Rick volunteered to meet with a conservation officer outside of the local grocery store to offer up details of his trip to the trail on the day in question. Rick tried to assist with the investigation and told the police that he did recall seeing 3 younger girls on the trail that day. His contact with the girls was brief and of little significance. Rick does not recall if this interaction with the conservation officer was tape recorded, but believes that the conservation officer scribbled notes on a notepad as Rick spoke to him. After Rick shared this information with law enforcement officials, he went back to his job at the local CVS and didn't hear from the police for more than 5 years. The next time Rick heard from the police was in October 2022. This was approximately 2 weeks before a contested sheriff's election and within days of a federal lawsuit filed against the Carroll County Sheriff's Office by its former second-in-command, Michael Thomas. In the lawsuit, Thomas claims that he, Thomas, quote, had made suggestions and offered assistance in the investigation of a high-profile child homicide investigation, end quote. But those suggestions and offers were rejected by the sheriff. Thomas further claimed that the sheriff and others in the department feared the disagreements with Thomas would become publicized as a result of the political campaign for sheriff. Thomas claims in the suit that he was ultimately demoted and replaced by Tony Liggett, who later that year won the 2022 election for sheriff. Furthermore, Thomas claims he was also removed from high-profile cases. Rick was ultimately arrested on or about October 28, 2022. In the 5+ years since Rick volunteered to provide information to the police, Rick did not get rid of his vehicle or his guns, and he did not throw out his clothing. He did not alter his appearance. He did not relocate himself to another community. He did what any innocent man would do and continued with his normal routine. Anybody see anything that's... Does anybody agree with Gull yet? Right now? That they shouldn't be saying this stuff? Because it might potentially violate the rules of professional conduct. We're so glad you made it to this live, that girl, James. Anybody? Nope. Me either, Bobby. Okay. The probable cause affidavit seems to suggest that a single magic bullet is proof of Rick's guilt. It is a bit premature to engage in any detailed discussions regarding the veracity of this evidence until more discovery is received, but it is safe to say that the discipline of tool mark identification for ballistics is anything but a science. The entire discipline has been under attack in courtrooms across this country as being unreliable and lacking any scientific validity. We anticipate a vigorous legal and factual challenge to any claims by the prosecution as to the reliability of its conclusions concerning the single magic bullet. On Rick's behalf, we argued to have the PCA unsealed. Rick has nothing to hide. As importantly, we were hoping that we would receive tips that would assist us in proving up his innocence. Not surprisingly, we have been inundated with tips from a variety of sources, all of which will be vetted by our team. Although it is a burden of the prosecutor to prove Rick's guilt beyond a reasonable doubt, the defense team looks forward to conducting its own investigation concerning Rick's innocence. We appreciate those that have reached out to support his cause. You know, it almost reads like they read the rules of professional conduct, those particular, 1 through 6, and then the additional however many were, there was like 5 extra ones. It's almost like they read them and then wrote this going off of the things that it says that they may say, in my opinion. The prosecutor mentioned at the last hearing his belief that others may have been involved in the killing, yet there was no mention in the PCA about a second suspect involved in the killing. The defense is confused by such discrepancies in the investigation and will be in a better position to respond as more discovery is received. I think it's important to point that out. It was important for them to point that out because were they investigating other people, or did he just say that because he didn't want the affidavit to be released? If he didn't want it to be released, why not? And someone asked me the other day if I thought that somebody else was involved, and the answer is yes. But the fact of the matter is that regardless of whether I think there is or not, if they're not investigating another person, then what does it matter? It says, Rick Allen owned a Ford Focus in February of 2017. His Ford Focus is not in any way similar to the distinctive look of the PT Cruiser or Smart Car that was described by the witnesses. It seems that the Carroll County Sheriff's Department is trying to bend facts to fit their narrative. So if anything, they've been very consistent. This is December 1st, 2022. At this point in time, we have received very limited information about this case and look forward to having something more to view than that which was offered up in the sparse PCA. Moving forward, it is our intent to scrutinize the discovery as it is received and give the necessary attention to the volumes of tips that we are receiving. To the extent we continue to discover information that points to Rick's innocence, we will offer up this information to the public, so long as we are not prohibited from doing so as a result of the recent request by the prosecutor for a gag order or by the Indiana Rules of Professional Conduct. And what does she do the next day? She signs the order for the gag order. It's like, oh, no, you won't. And then they sign their name. So that's the whole that's the press release. That's the press release. Please explain to me what was so bad about that warrants disqualification. She was annoyed at them for that. That was her second accusation. There's a couple more, but we're an hour and a half into this. We're probably going to have to make part 2. I want to know what you guys think. Like, so far, do you see, I mean, even if you're being critical, do you see why these 2 accusations were concerning for her enough to where she included them on the list, the short list of reasons why she removed them? She said that the first motion, that motion to transfer him, had a lot of inaccuracies. We all went through it. We couldn't find any. Yeah, she is biased AF. Oh, 100%. Deed said so far, this is all tame compared to other trials. Like, they're doing their job, man. Like, that's their job. To be honest, I thought that was way better. Like, thinking about it and putting out a press release is likely way better than, let's say, doing a press conference and answering questions afterwards. Like, you put out the press release and it is what it is. And you have time to think about what you're going to say. And you have others in your office look at it and say, okay, yeah, that sounds good. That doesn't sound like it violates any rules of whatever. You know what I mean? Get other input on it. Like, I often benefit from people proofreading the shit that I say because whatever filter a lot of people are born with, I was not. So, like, generally, I try to make it a habit to just kind of say what I mean. Mike says, I think he did it even though law enforcement screwed up. My question is, if law enforcement screws up, how can we be sure that they got it right? Like, do we think that he's the right person because law enforcement does? You shouldn't. And I am pro law enforcement, but you shouldn't. That should not be the only reason that you think he did it. Yeah, Kat. Kat said, let's face it, half the battle is fought in the court of public opinion, and Lady Justice scales always dip to the state. Then a gag order is put out. All the while, there are leaks. I mean, that's true, but if you think about it, why, like, what is a good reason? I hear people say the state doesn't have to respond to this stuff because they know their case. They don't have to justify. They don't have to stick up for their evidence. They don't have to, this and this and that and that. Okay, which I get, but literally from minute one, there's been a lot of people doing literally everything in their power to make sure that the defense version is not out there to the public. Why? I'm just curious. Like, who would care? hmm This is an honest question. So, and you know why I'm comfortable in saying this is that, so Brutally Honest said law enforcement is willing to twist the witness statements for the PCA. So what else are they twisting? Seems like an honest question. And why I agree with that and lean towards that being a possibility is because when you're reading the probable cause affidavit, so one of the things that the defense told us was that Betsy Blair saw that old comet, right? And it was a different color, wasn't even black. So, but in the PCA, Liggett mentions that she sees a car, but he does not make any effort whatsoever to describe what kind of car she saw. And it's like one of those things like, you had to have omitted that because it didn't. So you instead then threw in this other witness's account where he says it looks like a PT Cruiser so that maybe you don't have to say what she saw because the reader is going to assume that she saw a PT Cruiser, same as the other guy. It's the purposeful omissions to me. I'm gonna pop on camera. Am I still dark? I give up. I'm gonna go to sleep soon. Oh, tomorrow we're driving all the way home. I'm leaving here. I'm gonna go back to my house where I keep all the lights on like I have stock in Pico. So what are you guys thinking? We still have to go through the rest of the stuff. Let's see. Yeah. This is why this is why I get, and not just this case, but like this is literally what I've been screaming this entire time. For every case that I cover, I'm like, you understand that this could be you, right? You understand how quickly this could be you? Into a pretzel. This case is the case itself has gotten so sidetracked because like at this point now we're dealing with actual issues with just him. Like if we even go to trial, I'd be shocked. I think they want him to die, to be honest. I hope I'm wrong. Yeah. It's so scary. It's so scary. It's so scary. It's so scary. It should be. It should be really scary. And the more that you like let it happen, the greater the possibility is that it is going to be you. You know what I mean? Like, if you keep allowing something to happen, it's just going to keep happening. And each time it happens, it's going to get worse and bigger. Stumble around in the dark. Look at that. Look at this. Look at the, can you see my, you can see my nails because they're blue. I'm like, I'm tan, but not that tan, but you can barely see us. This is out of control. We're living in the dark here. I need like one of those candles, like with the hook on it. It's got the little hook on it with the candle that lights and you like turn the knob and it's like oil. Do you know what I'm talking about? I need like one of those to go to the bathroom at night. An oil lamp. It is like ghost stories in the tent. I don't understand. I wonder if my computer's breaking. We'll have to, like, when I go home, we'll have to try because this is weird. I was worried it wasn't going to make it till January too, but then when it got pushed out, and then I really got nervous. I think he will make it to January. In fact, I think that if his lawyers come back, I think that they're keeping as much of an eye as possible on him that like nothing bad will happen. Like they were saying at the last hearing that he seemed to be doing better. He was a little bit healthier, and he had gained some weight. And so I'm hoping that the new lawyers will go, the old ones will come back, and they'll be paying attention again. And then they'll not be able to treat him like that because I think the reason that he got better was because people were watching. Does that make sense? I mean, it just seems like nobody gave a fuck before, but then as soon as they found out it was happening and they made them aware that they knew it was happening, it's a little bit harder to get away with weird shit. Yeah, this is true. I'm gonna put this up. And then we're probably gonna go. We're at an hour and 41 minutes. We'll do another one though. Because we still have other things. The only thing to save him is all the eyes on this now. This is true. Oh, if anybody is in Indiana, the 27th at the Supreme Court building, it's like 200. I'll have to pull it up. I'll post it. I'll post the flyer at 9 a.m. They're doing this groundswell. There might be some interesting people there that you might want to see. Wink. Bob's supposed to be there. Hopefully everybody comes. Hopefully it's really, really big. There's a big turnout. All right, you guys. I love you. I appreciate you coming. It's 11:08 here. I'm going to stumble around to put my jammies on. Mark Carver. Mark Carver. I'll have to write it. I'll have to write it down. All right, everybody. Wish me luck. Wish me a safe trip to the bathroom and back. Although I guess if like I broke my leg or something, we would don't stub your toe. I mean, I'd probably do more of these if I was confined to the bed. But we'll do a part 2. I hope everybody has a good night. I feel like I read too much and I didn't get to see what you guys were saying. But now I'm getting distracted. All right, I love you guys. Everybody have a good night. I'll talk to you all soon.